Carlos Rodriguez. I serve as the chair of the county's Board of Ethics. We're here following public legal notice of an investigatory review, specially called meeting today. And the first order of business is to declare a quorum. We have 6 members in attendance. A quorum is 5. That's what's required for us to do official business. The second thing I'd like to do is go one by one and ask the members to introduce yourselves and the entity that appointed you. Cynthia,
First,
please.
Good afternoon. My name is Cynthia Smith, and I was appointed by Sheriff Craig Owens. Sorry, I'm hoarse.
Good afternoon. I'm Winter Wheeler. I was appointed by Chief Magistrate Judge Brendan Murphy.
And again, I'm Carlos Rodriguez, appointed by the Probate Court Judge Kelly Wolk.
My name is Ron Yonker, and I've been appointed by the State Court Clerk, Tanisha Phillips.
Leilani Plendle, appointed by the Board of County Commissioners.
Good afternoon, everyone. Tanya Bird, appointed by Cobb Tax Commissioner.
All right, thank you, everyone. And I understand that an oath needs to be administered to the members of the board, and our counsel and recording secretary, Lynn Rainey, is going to head that effort.
Okay, we have 5 of you who have been reappointed with terms beginning in January. One of you, Ms. Bird, is newly appointed to the board, but all 6 of you need to be administered an oath, so you can sit where you are. Just raise your right hand, please. Do each of you swear or affirm that you will faithfully administer and fulfill your duties as a board member as provided in the Cobb County Code of Ethics? If so, say I do.
I do.
I do.
Okay, thank you.
Thank you, Lynn. Before we begin with the investigatory review, that matter on our agenda, I'd like to lay out a roadmap for the parties, but also those members of the public that are in attendance. We do have some folks that are here with us. The investigatory review, this is a procedural step that the board is required to do following the board's receipt of a complaint. Deliberations and a decision must be done out in the open before the public. No decision has been made. While it is true that the decision ultimately that the board makes is based on the contents of the complaint that was filed and in consideration of the response that was given from Chairwoman Cupid. There's no evidence, there's no witness testimony that the board's going to be hearing today. What I think is an effective way for the board members to understand the nature of the complaint, but also for the public to know the nature of the complaint, because the public probably doesn't have a copy of the ethics complaints that are filed, is to have an opportunity for question and answer of the parties, have an explanation of the allegations in the complaint to see if it meets those necessary requirements in order for the board to move on to the next step, which would be to have an evidentiary hearing, or to decline to do that and find that there are insufficient allegations and therefore dismiss the complaint. And while we're using the commissioner's room, this isn't like a commissioner's meeting where there is an opportunity for public comment, okay? So there is no public comment. While we're not judges, this is quasi-judicial in a sense. And so what I would ask, to be fair to the members of the board, to be fair to the parties, Mr. Lamberton and counsel, Mr. Belinfante, is to exhibit some decorum and some respect, please. So no, don't holler anything out That's just not fair to the parties. That just distracts from what we're here to do and listen to. So I would just please ask you to, like if you were in a courtroom watching a trial and if it were possible to actually observe the jury's deliberations, please don't holler out anything at the jury, kind of like that. So I wanted to lay out perhaps some guardrails and expectations for everybody before we got started. So right now I'd like to invite our special counsel, Daryl Sutton, to introduce the pleadings and the legal considerations for our board to consider.
Thank you, Chairman. Excuse me. The purpose of this public meeting of the Cobb County Board of Ethics, which is being broadcast on TV 23, is to conduct an investigatory review to consider a complaint filed by Lance Lamberton against Cobb County Commission Chairwoman Lisa Cupid. The Ethics Board is required to proceed strictly in accordance with the Cobb County Code of Ethics. We will follow the rules provided by the code and will take such action as is authorized and required by the code. The board will be transparent, fair, and impartial to each of the parties. The code provides that once a complaint and a reply to that complaint are filed, an investigatory review is conducted. This review must be conducted in public, as we are here today to do, with the board members having, not previously met or discussed the matter. The board members have received copies of everything the parties have filed and had the opportunity to individually review those in the privacy of their own homes and their own offices. Today will be the first time that the members will have to discuss the matter. Nothing has been decided prior to today. The sole purpose of an investigatory review is to determine whether specific substantiated evidence from a credible source or sources exists to support a reasonable belief that there has been a violation of the Cobb County Code of Ethics. Mr. Lamberton and Chairwoman Cupid, this is your opportunity to tell the Board of Ethics in person why they should either proceed or not proceed with this complaint. The Ethics Board will not be hearing your testimony or testimony from your witnesses, nor receiving other evidence during this investigatory review. Only the affidavits, documents, and other materials already filed with the clerk of the County Commission and previously provided to the Board of Ethics can be considered by the board during today's proceedings. You are invited to state to the board how the materials already filed support or do not support a reasonable belief that there has been a violation of the Code of Ethics. Please understand that Mr. Rodriguez, the chairman of the board, has a responsibility to ensure this meeting proceeds in an orderly, civil, and respectful manner within the bounds of the Code of Ethics. And so he must retain the discretion to limit or terminate your presentation should it stray from matters subject to the board's jurisdiction. The board will hear first from Mr. Lamberton. When he is through with his presentation, the board will hear from Mr. Belinfante, counsel for Chairwoman Cupid. The board will then discuss the matter here in public and take a vote. If a majority of the board members determine through that vote that specific substantiated evidence from a credible source or sources exist to support a reasonable belief that there has been a violation of the Code of Ethics, then a public formal hearing will be set at a later date at which both parties will be allowed to testify under oath, present the sworn testimony of witnesses, and present other evidence. If the board, after such a formal hearing, determines clear and convincing evidence shows any violation of the Code of Ethics, it may then issue a censure or a reprimand of the chairwoman. It may also consider Mr. Lamberton's request for injunctive relief. If, on the other hand, a majority of the board determines today, through its vote, that no specific substantiated evidence from a credible source or sources exist to support a reasonable belief that there has been a violation of the Code of Ethics, then Mr. Lamberton's complaint will be dismissed and this matter will be concluded. Mr. Chairman, I yield back to you so you can preside over the investigatory review.
Mr. Lamberton, if you would come to the podium there so that you'll be picked up by the microphone. Okay. I don't ask that you stick to like a time limit. I leave that up to you.
It won't be that long.
Okay, no, we appreciate that. But I mean, you take what time you think is okay. Necessary. I find it helpful personally if at the end of your presentation, if we have questions from members of the board, well, what I'd like is for you to stay up here and then If there are questions from other members, then you can field those from right there, and then we'll move on to Mr. Belenfante.
Very well.
Great. Thank
Okay.
you, sir. Whenever you're ready.
Now, I'm not much of an extemporaneous speaker, so I'm going to be I have prepared written remarks, and that might seem a little boring to you, but that's what I'm going to do. All right. I set forth the following facts which would be admissible in evidence before the Cobb County Board of Ethics. The nature of my complaint is as follows. Under compliance with applicable law, Section 245 of the Ethics Board, quote, "No officer shall engage in any activity or transaction that is prohibited by law, now existing or hereafter enacted, which is applicable to the officer by virtue of that person's office," close quote. Under this provision, I maintain that Lisa Cupid, in her role as chairwoman of the Cobb County Board of Commissioners, is an ethical violation of the aforementioned section of the county's ethics code. And I'm therefore seeking injunctive relief in the form of censure and reprimand by this board. My evidence of the violation is as follows. Ms. Cupid currently serves and has served as the chairwoman of the Cobb County Board of Commissioners during the period of time which I allege a violation. In that role, she is sworn to uphold the laws of the state as per Section 245. Specifically, Georgia law prohibits governmental agencies from expending public funds to support any campaign committee, political action committee, or other political organization for any purpose. More importantly, the Board of Commissioners are further prohibited from spending public funds for advertisements, flyers, mailings, or any other direct promotion in support of passage. Where am I? I'm sorry. I'm sorry. Hold on. In passage of a SPLOST. Okay. And that's under McKinney versus Brown, 242, Georgia, 456, 1978. On the other hand, local officials may use county or municipal funds to prepare descriptions of the SPLOST proposal and the impact of the SPLOST projects on the county and its citizens. It is critical, however, that such descriptions not express an opinion regarding the SPLOST proposal or advocate which way a person should vote. However, in the information provided by the county's Department of Transportation about the mobility SPLOST proposal that was on the ballot, which was paid for with taxpayer funds, there is an obvious bias in support of the mobility SPLOST. There can be no doubt that the content of the videos and printed materials provided by the county clearly and indisputably advocate in favor of the MSPLOST passage. One video and printer flyer states, quote, "This initiative seeks to improve the county's transit infrastructure with a focus on safety, flexibility, and reliability tailored to meet the specific needs of our growing community and local economy." Close quote. Moreover, county staff, including the county manager and the director of the Department of Transportation, among others, are enlisted to make these advocacy statements in the videos. Quote, "MSPLOST can make transit faster, more frequent, and more reliable. It helps you to bypass traffic like when you are in a train," quote. Or, "The Cobb Transit Plan could transform bus stops and transfer points, creating a safer and more welcoming, accessible experience." Or, quote, "Check this out," exclamation point. "Discover how transit is connecting our community with opportunities to find out how Cobb's MSPLOST referendum could expand transit services in our county." In touting microtransit in one of the DOT flyers, he claims that it will provide essential transit services for seniors. The word essential is highly problematic. There is a very strong value judgment attached to this word and is a contention which is highly debatable. In one of the DOT flyers, the MSPLOST project list including the following assertion of benefits: community-tailored transit which provides safe, flexible, and reliable service options, expanding opportunities, inclusive access, and economic vitality. On the county website, it says the tax, quote, enables the county's infrastructure to keep pace with current and future mobility needs, supports business growth and resiliency, reduces traffic congestion, and promotes environmental sustainability, close quote. For those of us who oppose the MSPLOST, we argued forcefully and effectively that MSPLOST would do none of the above. Clearly, the language of these statements, which includes such exclamatory, value-laden words like economic vitality, business growth and resiliency, promoting environmental sustainability, are intended to explicitly get the voter to vote yes. What other purpose do they serve? Certainly not education and informational, but rather a bold-faced assertions about how the MSPLOST is the next best thing since sliced bread. To add insult to injury, these advocacy materials are clearly designed to sway voters just as much as the most slick and sophisticated advertising campaign that one would ever encounter in print or on television. The most egregious example of what I'm talking about is a flyer with a beautiful photograph of the entrance to Truist Field with a big bold sign of the Atlanta Braves, taken obviously during a busy game day, with the caption underneath it that reads, quote, connecting more people to more destinations, close quote. That sounds like an advertising slogan for a major airline, like Delta or American Airlines, or something that would be published in the National Geographic. It makes me wonder if the county used the same consultants as the major airlines to develop this kind of advocacy and advertising campaign. The state Supreme Court has also weighed in on this issue, ruling that, quote, county funds and county staff time should not be devoted to trying to get people to vote for or against any ballot question, close quote. Yet how could any reasonable person come away under any other conclusion but that the propaganda put out by the county is anything other than explicit, unequivocal advocacy in favor of MSPLOST passage? Which brings me back to my complaint against Ms. Cupid. As the highest elected official in county government, it is incumbent upon the chairwoman to exercise her authority to prohibit county staff from producing and disseminating materials which clearly fall within the realm of advocacy and is prescribed under state law. In short, those who make the laws should not break the laws. My complaint is not so much what she has done, but rather what she has not done as a constitutionally elected official who was sworn to uphold the laws and Constitution of our state. Therefore, I petition the Ethics Board to consider my complaint so that it may provide redress for my grievance. Thank you. That concludes my statements.
Thank you, Mr. Lamberton. I guess I'll start off. Let me ask you, you mentioned that the Supreme Court, you're talking about the Supreme Court of Georgia, weighed in on this issue. Did they weigh in specifically on the materials that you referenced regarding
not
the
on
Cobb
my
County
complaint
MSPLOST?
specific to my complaint, but I'm using the logic of you look at the language of the law and what the court has said, and you can in my mind at least, you can easily apply it and make it applicable to this particular situation.
Okay. Understanding that while there may be lawyers on the board, we're not judges, and I'm skeptical that we're the appropriate forum to determine what is lawful and unlawful. How is it that, based on your complaint, we're supposed to accept your analysis of what is legal or illegal about the use of public funds?
Well, I mean, I can cite specifics if you're willing to go down that far as to the particular law that I referenced, but I think it's applicable regardless because, you know, if the law says that you're not allowed to steal, and you want to prosecute somebody for stealing something, you don't have to specifically say, oh, the law says that's against the law. We know that's against the law, and we can cite that
Well, you agree that that's not the same thing that we have here. I mean, you're asking this board to find that what a county commissioner did was unlawful, despite the fact that no court has found that what anyone did was unlawful.
Well, the law does state that it's unlawful to use taxpayer funds to advocate for the passage or defeat of the MSPOS. And that is specifically and exactly what she's done based upon the presentation of the items that I presented to the board here.
Now, your complaint doesn't allege that Ms. Cupid advocated for the passage of MSPOS.
The materials that were put out by the county were advocacy materials that was paid for with an allocation of $187,000 from the general fund.
Now, let me stop you there. Where in the complaint do you allege that county funds were used to fund those materials?
I guess that one slipped my testimony. I probably should have put that
Well, there's
in
no
there.
testimony, right?
I probably should have, you're right, I probably should have put that in my testimony that, and part of my complaint is the fact that public's monies were spent to advocate for the passage of the MSPOS. I mean, there's a lot of ways that you can advocate for the MSPOS. There was a couple of committees that were set up that were spending money to promote its passage, and that's perfectly proper. It's perfectly proper for Ms. Cupid to go on her own time and speak before people in favor of passage, and she did that. But to take $187,000 of our money to advocate for the passage of the mobility SPOS is, I don't know. I mean, maybe I'm being simplistic about this, but that's just wrong. And she should be called to account for that.
Any other members have questions of Mr. Lamberton?
Yes, I had a question. How do you differ between the county's ability by law to describe the impacts of a tax, which might be defined as maybe the result of the tax? What happens as a result of the projects and the money? How do you describe an impact versus an advocacy?
An impact would be to say, okay, we're going to spend this much money on these projects. These projects consist of this. And by doing that, you're saying, okay, a certain amount of money is going to go for microtransit. Some of the money is going to go for bus rapid transit. This is the amount of increased coverage, factual information that I think that the counties actually should be doing that. I mean, if they're going to put something like this on the ballot, they should talk about its impacts and its costs, the duration, 30 years, $11 billion, how much they're supposed to raise. But when they go beyond that in the quality, the language of the communications that they put out, then you've crossed the line, in my opinion, as far as what the county should or should not be doing or be able to do.
If the expectation is, to Mr. Yonker's question, if the expectation is for there to be more reliable 73 miles of bus rapid transit, is that not a neutral explanation of the expected results of MSPOS?
Right. I mean, it's okay to say that there's going to be increased service, that there's going to be transit centers that are going to be provided. It's going to cost this much to do that, but in much of the materials that they put out, like the examples that I established in my opening statement, I think we definitely have crossed the line, you've gone beyond the pale. They've become very much advocacy, almost like a professional advertising campaign for TV or for radio or for print. I mean, I can cite back the examples that I read to you, but you've already heard it.
Anyone else? I've got one question. This is in response to the chairwoman's reply. Her counsel claims that the statute that you cited, 21-5-30.2B, that it doesn't apply to the allegations made in your complaint because it lacks any evidence of an unlawful contribution to a prohibited entity. I'm just curious if you had a response to that.
I'd have to look, I don't have that in front of me, so I'm not familiar with it, and I don't think I really would be qualified to answer that specifically.
Okay.
Okay?
All right. Thank you, sir. Anyone else?
So my question was, you're saying her action was her inaction?
Yes, that it was, I'm saying that it was her responsibility to make sure that the money that was being spent in an educational campaign be an educational campaign. And when it went beyond that to elder advocacy, it was her responsibility to keep control of that and not to allow that to happen, because she is the chief executive officer of the county. And you know, county employees, she has a responsibility to make sure that she does behave in a way that's appropriate. Because I mean, I think it was, okay, I don't know much I can say than that. That's all. I don't know if I can say any more about it than that.
Thank you.
Okay? I mean, the buck stops with her, so to speak.
All right. Thank you, Mr. Lamberton.
Okay? Are we
Mr.
done?
Belenfante, whenever you're ready.
Okay, thank you. Thank you for your time.
Good afternoon, members of the board. My name is Josh Belenfante. I'm with the Robbins firm. I'm here on behalf of Chairwoman Cupid. I first would like to thank the board for moving this, which I know was originally scheduled for 3:30 to 4. That allowed me to get here from Augusta, where I had a different hearing this morning, and I appreciate that. As you saw from our response, we're asking that the board dismiss the complaint because it neither alleges sufficient facts to allow the board to determine that there has been a violation by the chairwoman, and that's important. And also, it does not allege a violation of state law, which is the purpose and the argument set forth in the complaint. As the board is aware, and you heard a moment ago, the ethics code at 2-786 says that in order for a complaint to proceed to a full hearing, it has to allege specific, substantiated evidence from a credible source. And then on the law, it must support a reasonable belief that there has been a violation. The law that is cited in the complaint is Code Section 2-45 of the Ethics Code, which says that no officer shall engage in any activity or transaction that is prohibited by law. Now, what is the law that is at issue? It's not the Cobb County Ethics Code. It's not, for example, Code Section 2-54, where someone would disclose unlawfully confidential information. That, you just look at the Ethics Code. Similarly, 253, solicitation of gifts. So what this one is about is that there's been a violation of state law, and that's the engaging in a transaction that has been prohibited by law. On the facts, it's insufficient because it doesn't cite anything that the chairwoman actually did. If you look, engage as a definition means to do or take part in something. Here, who is alleged to take part in something? The Department of Transportation and the county manager. In Cobb County's form of government and its ordinances at 2-33C, the county manager is the one that directs staff what to do. There's no allegation, no citation, no identification of anything in the county budget that it was a vote of the commission and possibly the chairwoman to authorize spending on this event. There's nothing alleged that there was a vote or resolution by the chairwoman directing the Department of Transportation to do anything. So she really hasn't done anything. And you heard that today. Mr. Lamberton's very open and candid and should be commended for that. He's not talking about anything she did, but something she didn't do. And the ethics code says that's not the standard. It has to be something that the person actually did. And that makes sense. Otherwise, if any official in Cobb County were to do something, the chair or arguably any member of the commission would be responsible, whether they did it or not. And that's not what the Code of Ethics says. So there's no factual basis to support a specific substantiated evidence of any action by the chairwoman to engage in any activity or transaction that is prohibited by law. So then we turn to the question of is there any legal basis to proceed? The answer again is no. As I discussed, the issue is not the Cobb County Code itself in terms of a violation of the Cobb County Code. It is rather state law. And in Code Section 21.5.30.2, which is the statute cited, it does prohibit counties from, and I'll read it, no agency, which is in here the county, or person acting on behalf of the agency shall make, directly or indirectly, any contribution to any campaign committee, political action committee, or political organization, or to a candidate. I'll get it, and there's an exception that doesn't apply. Here, you have to then look at how does that code section define contribution, and it is a gift, subscription, membership, loan, forgiveness of debt, advance or deposit of money, or anything of value conveyed or transferred by or on behalf of an agency. So it has to leave the agency. It has to leave the county and go somewhere else. Where does it have to go? To a campaign committee, a political action committee, a political organization, or a candidate. The purpose of that statute is to prevent public funds from going to, understandably, candidates running for office, or political action committees that support a candidate running for office, or a third-party political action committee that may support a referendum. If, for example, the argument were and the allegations were that there was a vote to send Cobb County taxpayers' money to a political action committee to support the MSPLOST, that might be a different story. But that's not what is alleged here. What is alleged here is that the Department of Transportation had a video that advocated. That is not what the statute addresses. It's not what it discusses. So there is no legal basis to proceed. You heard about the Supreme Court of Georgia's decision. The complaint cites the McKinney and Harrison decisions. I will say that both of those decisions predate the statute, and so it's now the statute that controls. But also in those, you had facts where there was $37,000 in the McKinney case of public funds that was directly to influence the voters. And if you read the facts of that case, there was no question at all, and it was against the county, which made more sense. Harrison, same thing. Both were there. And I'll just address very briefly Mr. Yonker's question about how do you draw that line between describing an impact or the intent of the MSPLOST and advocacy. And it's a very difficult line to draw. What I heard Mr. Lamberton explain is that it started out saying the intent of the MSPLOST is all of these things. Well, if you're describing the intent, that would get into why someone's doing something, and presumably there are good reasons to do. But that line drawing is why the Supreme Court has said, in context of the First Amendment, when you look at what does advocacy mean, it has to be really crystal clear. And in a decision from 1976 that is still good law, Buckley versus Vallejo, they said, here's how we know when someone is engaging in advocacy or express advocacy. You see what's called magic words: vote for, elect, support, cast your ballot for, vote against, defeat, or reject. None of those words are in what I have seen as the Department of Transportation video. So in the end, members of the board, we respectfully ask you to dismiss the complaint or have it not proceed because there's no factual basis about any action of the chairwoman. There's not a factual allegation that she knew of the video, directed the video to proceed, voted to expend money on the video, and on the law, there is no contribution as is defined in the relevant state law. And with that, if there's any questions, be happy to answer. Otherwise, that concludes my remarks today.
Yeah, Mr. Belinfante, let me ask you kind of a similar question that might help me with my skepticism of us, the Board of Ethics, being the appropriate forum to decide what passes this constitutional test. right? We're not the Supreme Court of Georgia. We're not the Superior Court of Cobb County. Are we, the Board of Ethics, the appropriate forum to decide at first instance whether something is unlawful just right out the gate?
I think if there was something, the example Mr. Lamberton gave where it was either there's been a conviction.
Right.
That's a violation of law. If someone has been found to engage in a transaction that is prohibited by law by a court or someone else. But your code, and we cite the cases involving the State Ethics Commission in our response, has to be construed very narrowly. And so you take a gray area and you have to interpret it in every way in favor of the chairwoman. And so given that as well, without a determination of unlawfulness by a court, there's not a basis really to proceed. But here, I don't even know that the board has to get to that question of the law, because there's no allegation of an engaging or transaction or engagement in a transaction by the chairwoman. And that alone could probably suffice. But I think, Mr. Chairman, you raise a good point. And certainly, given that the law favors both in the First Amendment context, but also in the context of ethics type laws, are in favor of the person who something's been alleged against, that is the probably better response to take.
Thank you. Any other members of the board have questions for Mr. Belinfante? Can jump right in if you do. All right. Seeing none, thank you, Mr. Belinfante.
All right. Thank you.
Appreciate it. So now would be the opportunity for members of the board to enter into the discussion deliberation stage. Obviously, this is out in the open for all to hear and see. Mr. Yonker, do you have any thoughts? Can I start with you? Sorry to put you on the spot. You're the vice chair, so.
Well, for me, in looking at this, going past the law, if I were to say, okay, well, did the statements that were made in the allegation here, in the complaint, what would I reasonably expect in terms of the definition of impact? And that, for me, was something that I looked at very seriously. And if I were to change the words to where the county would say, the NSPLOS can make transit slower, less frequent, and less reliable, would I expect that as part of their education to the public in terms of what they're going to get for the tax? And I just don't think that's reasonable. Also, using the words can, could, they don't say will do this. They say it can be done. So I don't see, just from that standpoint, where there's an explicit promise of the benefits of that, to where maybe it was going beyond to get people to think that this is actually going to happen, which might then convert to advocacy. So that's kind of where my thinking is going in terms of my question around intent.
Anyone else?
That's a good point, because I saw it the same way.
If you'll turn your mic on.
I'm sorry,
Cynthia.
I
Thank
saw
you.
it the same way, especially when you mentioned the word impact versus intent. So thank you for bringing that up, because I was kind of confused there too. The could, the can, possibility. I was kind of stumped on that.
What I keep going back to is the ethics in the Section 245, compliance with applicable law. No officer shall engage in any activity or transaction that is prohibited by law. So again, that's the one thing that I keep seeing is what is the law that was broken? And I appreciate the clarification that there is no conviction, there is no court determination, so I do believe this is outside the bounds in that no law was broken that has been shown to us.
I have to agree with that. I don't think we are the right venue for that determination at all. Then, of course, on top of that, you know, the facts have kind of shaken out, you know, that there was no real engagement by Ms. Cupid. So, in my opinion, I just don't think that we are to handle this.
So let me share, I guess, I've expressed my skepticism about whether we are the right forum to determine at the outset whether something is constitutional. But, you know, our focus is way more narrow than just determining whether a law has been broken. I don't believe that that is our duty or charge at all. I like to step back and look at the actual policy of the Board of Ethics. And that's a responsibility to protect the integrity of government and to protect against improper influence or the appearance of improper influence by establishing appropriate ethical standards with respect to the conduct of public officials. That's section 2-42 of the county code. And what it goes on to explain is that the objective of the code is to prescribe only such essential restrictions against conflict of interest as will not impose unnecessary barriers against public service. And so if the backdrop and context of the Code of Ethics is to have a process where citizens like Mr. Lamberton can file a complaint that alleges that a county official has a conflict of interest of some sort, the appearance of impropriety, example of improper influence or financial interest in a action that a county official makes, then that is the appropriate matter for the Board of Ethics to weigh in on and to determine whether that complainant has provided specific substantiated evidence from a credible source to support a reasonable belief that a public officer has violated the Code of Ethics. But here, if we're looking at the four corners of the complaint, to Mr. Belenfante's point, there's not an allegation of an actual act, of a activity or transaction that is prohibited by law. Mr. Lamberton makes clear that it was the inaction, but there's nothing in the complaint that suggests that there was a determination that use of funds for the MSPLOST materials cited in the complaint, the flyers or the video, were unlawful. It doesn't even allege the amount of money. It doesn't allege that Chairwoman Cupid did anything. Even if we were the proper forum, my roadblock is there. We're looking at the complaint to determine whether specific substantiated evidence from a credible source exists to support a reasonable belief of a violation, and there isn't an allegation of a conflict of interest, there isn't an allegation of improper influence, there isn't an allegation of financial interest in making the videos or flyers, there isn't a specific substantiated claim that public funds were even used for the flyer or video. And perhaps that's an oversight on Mr. Lamberton's part, but to me, that ends it right there. We don't even have to determine what is a constitutional interpretation of state law, what the meaning of advocacy is. I just don't think that we even get to that point because within the four corners of the complaint. There hasn't been any alleged activity on the part of the chairwoman, not to mention the fact that there hasn't been a determination that funds for these flyers or videos were unlawful. I don't want to take anyone else's opportunity to share their thoughts and deliberations, I guess, about the complaint, but if there isn't, then I would invite a motion to find no specific substantiated evidence from a credible source existing to support a reasonable belief that Chairwoman Cupid violated the alleged code of ethics and dismiss the complaint. I'm sorry, sir, you're not allowed to speak. Sir, if you would please have a seat. So we can't consider anything other than what the parties have been presented.
$87,000.
Right.
It's part of the record, and you're just, oh, let's not do it. State ethics would do it. But you know what?
Thank you.
Just take your time. Cobb County's been guilty of this in the past, because I filed the state ethics in the past, and they used the water.
Sir, so there is no opportunity for public comment. I made that, I stated that out the outset, and you're just deciding not to follow what the ground rules are here, and I would appreciate if there be no more outbursts. Thank you. All right?
So moved.
Do I have a second?
A second.
Okay. All in favor say aye.
Aye.
Any opposed? Okay. The matter is dismissed. As far as the next board meeting, a date is to be announced. I would entertain a motion to adjourn.
Motion to adjourn.
Okay. Do I have a second?
Second.
Okay. All in favor say aye. Aye. All right. We are adjourned. Thank you. Thank you to all the parties.